So again, you're playing games, and you're being dishonorable, you're being deceitful. You have not
Miss Radio, Miss Radio,
yes.
please stop going down that line.
I would never agree to provide legal advice to a defendant on how to file an arbitration.
You yourself have filed as Exhibit A something that speaks of arbitration, correct? So you are in knowledge that there should have been arbitration before bringing it to court. You did not. You didn't.
We made no such acknowledgement, ma'am.
Didn't make no acknowledgement.
And we have not been deceitful. I find that offensive.
And if the court rules in his favor, I'll just have to appeal it, because there's nowhere have they been honorable in trying to get this squared away. And nowhere they have a lack of transparency, a lack of due process, because they either haven't given me the stuff on time or not at all for me to present an effective defense.
The case of Portfolio Recovery Associates LLC versus Shatina Grady, also known as Shatina Grady L.
Good afternoon, Your Honor. Daniel Best, P58501 on behalf of plaintiff, Portfolio Recovery.
Good afternoon. I should have also said case number 24C2622GC. Ma'am, could you state your name?
Shatina Grady L.
Thank you. All right, we're here today on these motions for summary disposition, cross motions again, as well as now Ms. Grady L has filed a motion for arbitration. I think we should start with the threshold matter of the motion for arbitration. Her claim is obviously that it is something that she's entitled to, and that the court doesn't have any discretion in allowing her to have that. The response file, which I have reviewed, argues essentially that she waived that particular right when she chose to go down the route of filing for a jury demand and having multiple hearings regarding this matter prior to filing for the motion for arbitration. So Ms. Grady L, it's your motion. I'll let you make any additional arguments that you want to make regarding that.
Okay, I never received the answer to this motion to compel arbitration either. I just would like to let the court be aware of that. I don't understand what is the reason that Portfolio Recovery and their associates tend not to send me information according to this case when they're supposed to send it. And to me, that is very deceitful. They are hiding something, and I am compelling the court to send this to arbitration, because they also have, for the public record, defamed my character, Shatina Grady L, by making false statements. They have said just recently in their response that I have not seen that you said that I shouldn't be allowed to go forward with this because I have asked for a jury. That is incorrect. I have not filed to have a jury. I asked about that before I did. So like this Portfolio Recovery is a very deceitful, and their associates is being very deceitful in this case.
So my notes in the file from the magistrate when you met with the magistrate was the defendant requested a jury trial. So that is...
I did speak with her about that. I asked if I could, and she said she did not know. She had to check. And if you needed to run back the tapes, that's exactly what happened, because I did not file any paperwork for that. But I asked when I spoke with her, and she said, I don't know.
Okay. Well, the bigger piece is that there have been multiple hearings on this matter and that you have not filed any. Well, I'll let him make his argument. Mr. Best?
Thank you, Your Honor. As detailed in our reply, we believe the defendant has waived the right to arbitration in this matter. I mean, this is the third hearing we've had on our motion for summary disposition and the related motions. This matter was filed in October of last year, November of last year. It's now May. We are in heavy litigation. Numerous pretrials have been held, numerous hearings have been held. Quite simply, the ship has sailed on arbitration.
And I would like to dispute that because according to you, you are saying that numerous ships have sailed, but your firm in handling this case has not handled it correctly. So you yourself have filed as Exhibit A something that speaks of arbitration, correct? So you are in knowledge that there should have been arbitration before bringing it to court. You did not. You didn't
We made no such acknowledgement, ma'am,
didn't make no
and
acknowledgement
we
for
have not been deceitful. I find that offensive.
in your Exhibit A, it distinctly says that any one who comes and takes said debt that you said you were assigned, you are held to the agreements of Synchrony Bank that there is to be an arbitration first before seeking to court. Now,
That is,
in
that is
my
correct.
opinion, that is not
You
my fault.
need to read the statement. You need to read the agreement.
The law is the law. I did read it. I have it in Exhibit A. Look at Exhibit A. Because I don't have a contract, neither does the defendant with you. And so your company has repeatedly failed to answer these motions or anything with the information that I have requested. And that
May
is
I read the provision?
certain
Would you
information.
like me to read the
All
provision?
right, everybody, please slow down and stop. She can't record all of that like the way you're talking right now. Mr. Best, please read what she's reading from as to whether arbitration is required.
Yes. If either you or we make a demand for arbitration, you or we must arbitrate any dispute or claim between you or any other user of your account and us, our affiliates, agents, and or dealers, merchants, retailers that accept the card or program sponsors it relates to your account, except as noted below. Basically, the noted below is the small claims provision, standard language, but the arbitration is elective. It's not required.
So I am requesting that the court compel this to arbitration because it says in 9 USC that the court, for staying the court proceedings when an issue is referable to arbitration. If a lawsuit is filed on an issue covered by an arbitration agreement, which there is one, okay, the court must stay, it says must, the proceedings and compel arbitration if the issue is properly referable to arbitration. So it does not say I have a time limit to, unless you can show me where it says that I have a time limit to request an arbitration.
Michigan case law is very clear about waiver.
So everybody stop. So Ms. Grady out, give him one moment since you didn't receive it. So we didn't address that issue. Her issue is that she never got the reply brief, but I want to handle this today. So I want to say that it was filed with the court on May 20th. Today is May 22nd. And I don't know whether, let me see, where's the proof of service on this? One moment.
And I am consistently, when I file paperwork, giving them notice of at least about 2 weeks or close to 2 weeks. And repeatedly, they are sending information to me at the last minute. And it is obstructing proper defense on my side because they are repeatedly, every single time they are sending things to this address at a late notice where there's only a couple days for review. I am sending it in enough time for them to view it, process it, and respond. They are not. They're being deceitful. They're not being honest.
So it looks like, Mr. Best, your office didn't put this in the mail. So you brought it to the court, apparently. It was dropped off. You brought it to the court and dropped it off on the 20th, but you put it in the mail to her on the 19th. There's no way possible she's going to get that.
We mailed it to the court. We received hers. Bear with me.
It was mailed on the 12th. Mailed on the 13th. Let me look at my receipt. I do have my receipt right in
Well, I
front of me.
think his point though, ma'am, is if you mail it to them on the 13th, by the time they get it and have time to
We
respond.
literally turned it around in one day, Your Honor.
Yeah, it's gonna have a very short turnaround time regardless. But this is not folded, so I think your office delivered it to us, Mr. Best. There's not, it could
Let
have
me
been put in one
double
of
check.
the.
I don't believe that is correct.
Well, I don't think
I
it's
think we
possible that
mailed it.
well, then if that's the case, I would have an issue because you mail it, it's not gonna get to us. If you put it in the mail on the 19th, it's not gonna get to us on the 20th. That's not
Yeah,
a,
we sent it overnight FedEx.
okay, did you send it overnight FedEx to her?
We sent defendant first class mail.
So she's not gonna get it, so she doesn't have it. So that means, Mr. Best, that you need to read the case law that you're citing to her so she can at least hear what you're saying is your argument, because she doesn't have the document.
Very good.
So again, I would have no time to respond. I am not an attorney. I don't have this terminology in defense.
Gradial, Miss Gradial, Miss Gradial, Ms. Gradial, I'm very, very aware of that. So please understand that I'm taking that into consideration, okay?
Thank you.
Okay.
Mr.
And
Best,
do you want me to read the germane paragraph, Your Honor?
correct.
Okay. The presence of a no waiver clause to arbitration does not alter the ordinary analysis undertaken to determine if a party has waived its rights to arbitration. Citing to S&R Company of Kingston versus Latana Trucking, Inc., 159 F3rd 8086 at page 86, Second Circuit, 1998, cert denied 528 U.S.
Mr. Best,
and 58.
Mr. Best,
Yes,
where are you reading from?
I'm reading from page 5 at the very top. I went to the top. Actually, I could go back a paragraph if the court.
Well, it's not numbered, first of all, but you're reading from page 3?
Yeah, I'm sorry, page 3. Yeah. Let me start at the bottom of page 2, unless the court would like me to start somewhere else.
No, that's fine.
Okay. In presenting a motion to compel arbitration, the moving party must do so without 1, taking actions that are completely inconsistent with any reliance on an arbitration agreement, and 2, delaying its assertion to such an extent that the opposing party incurs actual prejudice. Citing to Hurley v. Deutsche Bank Trust Co. Americas, 610 F3rd 334 at page 338, year 2010. It does identify a quoting case, and then it also identifies to see General Star National Insurance Company versus Administratia Aseguilar Distrat at 289 F3rd 434 at page 438, Sixth Circuit, 2002. Goes on that the presence of a...
Mr. Best, let's stop there.
Okay.
What is the actual prejudice to you?
We have spent a considerable time and effort briefing, appearing at hearings. We've engaged in litigation. That's all held for naught if the court now refers this to arbitration. That's valuable time wasted, including the court's time. And I believe we are definitely severely prejudiced in the number of times we've appeared before this court.
I would have to respond that I am also incredibly prejudiced because information I have asked for and the plaintiff has supposed to sent to me in a timely manner has not gotten there. I've too had to appear at these appearances. I too had to take time to do research, probably more than the plaintiff, because I don't know all the terminology. They have an upper hand. So I too have been very prejudiced. And then the plaintiff is trying to prejudice me even further by asking for finances that they have not yet or failed to prove that they actually deserve. The plaintiff has repeatedly, because the defendant does, I believe, in my opinion, does not have an attorney, has taken advantage of this situation or attempted to take advantage of this situation by not giving information late, and also filing, not responding how they should. I asked for specific information to even prove a contract between the two, not giving it. You were told by the court to send some unredacted documents that you put on public forum for people to see. It was placed on public forum, unredacted documents that should not have been. Those should have come to this address. So in your speaking of anybody being prejudiced, that would be the defendant is grossly. And I ask that the court compel this to arbitration, which is where it should have been in the first place.
Your Honor, I can only point out that the clause was attached to the complaint. The clause was, the arbitration agreement was attached to the complaint. So I have no idea what defendant is complaining about.
And I too said,
well, everybody please stop. What she's complaining about is the fact that when the request was made by her to get a copy of the documents that proved that this was a valid contract, her personal information was included mistakenly by your office with the documents that came to the court, as opposed to the documents that were supposed to go to her. They came to the court and were placed in a public file. So that's the prejudice that she's referring to.
Okay. And I would move to have that stricken.
Right, I understand that, and we will strike that. We've already instructed the staff to do so. But that's the argument she's making as far as that part is concerned, because she wasn't able to see the actual account to be able to know that it was her particular account. That has been something that she has stated from the very beginning. The second hearing that we had to have was because the documents were FedExed to her shortly before the hearing that we were supposed to have, and she had not had time to review them because she was out of town. The first hearing that we had was at the court's request for the matters to be briefed more thoroughly, because she had filed responsive pleadings and no one had briefed every single one of her responses so that we could have an actual hearing on each one of those. So there has been a lot of litigation. I understand that there has been a lot of litigation, and Miss Shatina Grady-L, Mr. Best is correct. The concept of an arbitration as it was indicated in this particular contract is one that is elective, meaning that a party has to elect to have it. They're not precluded from coming to court in this particular case, and they were not wrong for bringing this case to the court. However, you have now made a demand for arbitration in this case. And so as I see it, and Mr. Best can choose to appeal or do whatever, but as I see this, the issue before the court right now is whether or not there has been an extensive amount of litigation to the point that the plaintiff portfolio is actually prejudiced by that. They have expended a considerable amount of time coming back and forth to court here. But that does not, in my mind, equate to necessarily a prejudice. I am going to grant your request to compel this to go to arbitration. But what that means for you, ma'am, is you need to file the documentation to go to arbitration. I will stay it until you do that. I'm going to stay it for 30 days. If you do not file that in that 30-day time period, we will come back here and there will be no more requests.
The judge has just given her something most defendants never receive: a second procedural runway. Arbitration is elective, not automatic, which means it must be invoked correctly and on time. From this point forward, sovereign-style language about due process and deception is irrelevant. Deadlines now replace arguments. The claim that an email was mysteriously sent to the wrong address changes nothing. If she fails to execute the arbitration properly, there will be no further reset.
Yes.
So you need to file the monies and go to arbitration. The motion to compel arbitration is granted.
So I come today with to have my motion for dismissal requested. And
Ma'am, what happened with the arbitration?
So there was no arbitration because that attorney that took the information mysteriously emailed it to the wrong email. I called them on May 23rd, on June 9th, because I had checked my email. If you will recall, at the end of that last court date on the 22nd, the attorney that spoke or sat was supposed to send me information regarding arbitration. I checked the email every single day. There was nothing. On June the 9th, I called to find out why I had not received anything, and I had to leave a voicemail. I did that. I called on July the 1st to find out why I had not received anything and what is going on, because I'm still checking the email. Nobody's called me back. Nobody has reached out to me by mail, nothing. On July 2nd at 8:37 in the morning, they had a representative call me. When I spoke with Kelly at 3:02, finally getting in touch with someone, she said, even though this attorney at the last meeting repeated the email back to us, managed to misspell the email when they sent out the arbitration stuff. So as of today, when I checked, I still have no arbitration stuff, because on the 2nd, when I spoke with Kelly, I gave her the corrected email. I don't understand why this firm is unable to get me the information that I need, either not at all or in a timely manner. I don't understand why, when they can repeat back to me what I have given them per the email, that mysteriously one letter gets changed. So arbitration has not gone through on the failure of their behalf.
Mr. Best, response?
Thank you, Your Honor. I was that attorney. I repeated back the email address that was provided by defendant. I reiterated the E because it was not her last name. I mean, not her first name. It was Shantine, not Shantina. And I got confirmation. I completed the order, and it was an order of stay. There was nothing in that order that would preclude defendant from seeking the arbitration as was ordered by the court. So the email that was sent was not returned undeliverable. We did not have any notice that there was an issue until yesterday when my staff returned the call. Admittedly, we did receive ISHO on June 10th, a call that was misrouted by my receptionist and was not returned. But the bottom line is, at that hearing, the court gave defendant until today to initiate the arbitration. Nothing in that order was needed by her to initiate the arbitration, and the arbitration was not initiated.
So in response to that, at the last court date, I spelled out SHATINA G 317, and I said G for Grady, right? And so you repeated that back to me. First, you asked if it was the E, because in the new name, it is SHATEINA. And I said, no, it's not. You asked me, was it going to be spelt that way? Because it's different from what, and I said to you, no, not to that name. We're not spelling it that way. We're not using the E. I specifically said we're not using the E in Shatina, SHATEINA. And then I also said G for Grady, 317 at Gmail. But the email that you sent it to, if I'm telling you there's no E from what you see on my sign-in, SHATEINA, because that's what's on my sign-in, I told you to omit that E. That doesn't go there. We're going to it's spelled the way that it's in the court papers that you filed suit of. If it's in front of you, you filed suit for SHATINA. Okay. And then Grady. And then as to what you sent me, and you saying that the court said that I had to do, if I want to seek arbitration, she asked me, did I know how to do that? I said no, but I could figure it out. You said, well, I can send an email. Whatever your specific words, which is why I'm getting transcripts printed. I don't know what your specific words, but you cut in and said that you would send me the email. That's when we got to the email aspect of it. That's how we got to the email aspect of it, because I had said, she asked me, did I know how to do it? I said, well, no, but I can figure. And you said, well, I can send. You said, I'll send an email, or whatever your wording was. You didn't say anything about sending whatever you just said that you were going to send. So again, you're playing games, and you're being dishonorable, you're being deceitful. You have not
Miss Gradio,
yes.
please stop going down that line.
I'm just telling
Miss Gradio. The reality is that you came in here and you asked for an arbitration.
Yes.
And I stayed this matter and gave you an opportunity to file that. So,
but he also said, when you asked me, Judge, you asked me, and if you needed to run the transcripts back, we could do that. You said, do you know how to do that? I said, no, but I'm sure I could figure out. And he said, as a cut-in, that he has a packet that they normally send out. Nor not I have received that packet, but I didn't receive an email for it. I knew that I would probably not get any response until close to the court date. Like, I knew that. That's why I even called on June the 9th. That's why I even asked if there was a note I could send you at the court. And I was told no. I knew that they would try and do this, that their people called me just now, yesterday. And if the court rules in his favor, I'll just have to appeal it, because there's nowhere have they been honorable in trying to get this squared away. And nowhere they have a lack of transparency, a lack of due process, because they either haven't given me the stuff on time or not at all for me to present an effective defense.
Ms.
And
Grady,
if the court
Ms. Grady,
understand.
I've adjourned this case, I don't know how many times, give you an opportunity so that you can be prepared. So please don't interrupt me. Please do not interrupt me. Please. Today we're back here, and I'm not happy with either side. Because one, Ms. Grady, if he didn't send you the information, you could have done what you said you could do, which was figure out how to proceed with the arbitration. And Mr. Best, on this particular case, at each and every turn, there's something that comes up that doesn't go right, which complicates this matter even further. So if she's calling you guys, and now with that particular call, it gets rerouted, and like she said, she doesn't get the call back until yesterday. And as far as an appeal, appeals don't scare me, Ms. Grady. I don't mind that people appeal. That's for a higher court to decide if I've done something wrong. But I try to do my best to do the right thing by everybody that comes before me. And I've given you many opportunities. So, Mr. Best, I don't recall the specifics of that part as to whether there's a package.
I have no package, Your Honor. I have no packet. I have, and what I agreed was I would provide the order granting, or that's what I believe I was agreeing to provide, was the order granting defendant's motion.
I didn't
It's
get that.
normally the party who brought the motion's obligation to do the order. My remembrance was she did not know how to do the order, and I agreed to do the order because I have a standard one that we do on these cases. I would never agree to provide legal advice to a defendant on how to file an arbitration. I do recognize that my office did drop the ball with respect to the order and getting it to defendant, but I insist that the information I took down is what defendant provided. Granted, we did not properly follow up and we did not properly respond to her voicemails, but it's strictly the order.
And in reality, where we are right now is this court doesn't have an order in it referring it for arbitration or a stay or any of that because the order was never submitted to the court either.
So what I would propose is that we provide, I believe it was 45 days originally. I don't want to keep kicking this out, but we go out 45 days, which would roughly be August 18th. And that she file it by then. I am not providing her any instructions on how to do so. I will submit the order under 7-day.
So we are all clear, Ms. Gradiel. He's submitting the order that says that I granted a stay and that you are to file your arbitration within that time period. It will not say anything else or provide any packet for arbitration. It will be your responsibility to figure out how to file your arbitration. Okay?
I hear you, Judge, but I would ask for a dismissal.
That's not how this process works, Ms. Gradiel, and you can file whatever motions you want to file around that.
I feel biased upon.
Okay, then you can feel however you want to feel about that, and you can file whatever you need to file.
Your Honor, if I can, I'm actually out of town the 18th and 19th of August. I would like to be the attorney who handles this. Could we schedule that either? Yeah, I got a dentist appointment on that Thursday. Does the court hold these strictly on Thursdays?
Strictly on Thursdays, and the 18th wasn't an available date anyway.
Right. The 21st would be the available date. I do have a 1 p.m. dentist appointment, but if we could go, I have a very good dentist. If we can do it at 3 o'clock again, that would work.
We're not here on the 21st. He's not asking for that. He's asking for the next date, the 28th.
Okay, I'm sorry, I'm just wasn't sure if you had originally given that.
No, I did not.
Number of days.
Mhm. So counsel, you're gonna submit the order granting the stay and providing her with 45 days to file her arbitration. And
Correct.
that be submitted under the 7-day rule. Ma'am, the 7-day rule provides that once the order is submitted, you have 7 days to provide any objections you may have to that order. Court date will be scheduled for August 28th, 2025 at what time, please? 3 o'clock p.m. This is the last date for that arbitration to be filed. If it is not filed, once again, I will tell you, your MSD will be heard that day. His MSD will be heard that day if it is not filed.
And just for clarification of the order, is it 45 days from today's date 45 days from the entry of the order or by August 28th.
Let's just make it by August 28th. When we come back here, that arbitration needs to be filed.
Very good.
Thank you.
Thank you. Have a good day, everyone, and a happy.
This case stopped being about arbitration the moment the stay was granted. From that point forward, it became about responsibility. The judge issued a clear directive: file the arbitration by the deadline, not wait for a packet, not wait for instructions, not wait for the plaintiff to act honorably. File it. What we are witnessing is a familiar sovereign-adjacent pattern, shifting attention away from obligation and toward perceived unfairness. The defendant repeatedly frames the issue as dishonor, bias, or deceit. But courts do not rule on narratives or feelings. They rule on compliance. The plaintiff's office has acknowledged errors: misrouted calls, unreturned voicemails, and confusion over an email address. That may affect credibility, but it does not relieve the defendant of her burden. Once the court says, "You must initiate," the procedural responsibility is hers alone. The ball is in her hands. Here is the quiet danger. When someone believes the system is stacked against them, they begin acting defensively instead of strategically. They wait for perfect fairness before taking action. Courts do not require perfection. They require performance. If arbitration is not filed by the deadline, the summary disposition motion will be heard. The debt case will then proceed without the arbitration shield she fought so hard to invoke. In sovereign citizen circles, phrases like lack of jurisdiction and failure of due process are common. But those arguments collapse when deadlines are missed. The judge is not debating philosophy. She is measuring compliance. And in court, compliance decides outcomes. The next hearing will not be about who acted deceitfully. It will be about who followed the court's order.